Namaskar. Good evening to all. I, on behalf of Adhivakta Parishad Mumbai Unit, welcome you all in today's 14th lecture of this Shri Dattopant Thengadi lecture series. I must announce that today is the second last lecture of this series, and today we have uh, one of the best eminent judge of the Bombay High Court, retired Judge Shri Justice Ambadas Joshi. He will address on the topic of how to read statutory provisions and how to understand it. Uh, Before starting our lecture, today's lecture, I request Advocate Shweta Nayak to introduce today's speaker. Advocate Shweta Nayak.
Thank you, Pravartak. Thank you so much. Good evening, everyone. On behalf of Akhil Bharatiya Adhivakta Parishad Mumbai, it is my great pleasure to introduce Shri Justice Ambadas Joshi. Sir has completed his graduation in BA from Marathwada University and also completed his graduation in law in 1976 with a distinction and as a topper in the university. Sir's achievements are quite exhaustive, but I will try and sum them up in few words. Sir started his practice as an advocate in September 1976, practicing at Beed, Aurangabad, and then in High Court bench at Aurangabad since 1982. He worked as an assistant government pleader and additional public prosecutor since the year 1987-88 at Aurangabad High Court. Sir was appointed as a special counsel for the State of Maharashtra in many cases, service matters, writ petitions and appeals arising out of land acquisition, civil supplies, labor laws, etc. He has also represented plenty of private litigants in civil, criminal, labor law, election public trust, company matters, and cooperative laws. Sir was elevated to the bench of Mumbai High Court in 2004. He worked at Nagpur bench for 8 years and was also a visiting judge at Panji and Mumbai. Sir retired while he was presiding at Aurangabad bench. Joshi sir presided over various other benches as single judge in various assignments, as junior judge in division bench, as a senior judge and as a senior judge on division bench, hearing assignments on inter alia, writ petitions, labor laws, service laws, criminal laws and company laws. Sir has also presided as chairman of Maharashtra Administrative Tribunal in July 2014 and retired as the same on July 2019. He has been a visiting faculty at Dr. Babasaheb Ambedkar Law College, Aurangabad for 10 years for various subjects, at Institute of Management and Research to teach labor law and company law, and at State Bank of India's Officers Training Center, Aurangabad. Sir has organized and conducted workshops on mediation at Nagpur and also wrote a book as a practical workbook for guidance on meditation, which is published and circulated by Maharashtra Legal Services Authority. He has been volunteering for various social activities. He was also the chairman on Devgiri Sahkari Bank Limited and an active Rotary Club member. Sir is humble in nature and loves trekking and has varied interests like agriculture and horticulture, water and soil conservation, naturopathy, and also coaching the youngsters in personality development. Sir is presently settled in Mumbai, consulting in arbitration matters and occasionally practicing at Supreme Court of India. Once again, sir, we are honored to have you with us today and request you to enlighten us on reading the statutory enactments, laws, and understanding them. Thank you.
Thank you so much, Shweta. I must inform to the viewers that today's lecture will be a bit interactive, as today we have two participants along with Justice Ambadas Joshi sir. The volunteers are Advocate Shweta Nayak. Along with Shweta Nayak, there will be Advocate Ritvik Joshi. Now I request Justice Ambadas Joshi to take over. Sir.
Namaskar. Namaskar. Good evening. I hope I am audible to everybody. Am I audible to everybody?
Yes, sir. You are audible.
there is a connectivity issue, data issue. Let all other videos be closed as well as the mute be closed. Mute the phones so that data will be freely available for my expression. Yes, can anybody indicate that everybody is able to listen to my voice?
Yes, sir, we are able to hear you.
Okay, I did not get a response, so I just wanted to make it sure. Friends,
Yes.
normally there is a possibility.
I think there's been some connectivity issue at his end again.
Yes, am I connected?
Sir, we are unable to see you.
Okay, there was a difficulty in connection. I'll get you on with the line.
Yes, sir.
Justice Joshi will join us in a moment. Meantime, I request Advocate Shweta Nayak to share her experience about today's program, that Lozi, that one of the wonderful game which was arranged by Akhil Bharatiya Adhivakta Parishad Mumbai Unit. I request Advocate Shweta Nayak.
I think he's back.
Joshi sir, you're not visible. I think you're
getting connected. Okay. Yes, can you hear me?
Yes, sir.
Yes, okay. Okay, sorry for the, I'm extremely sorry for the interruption. Friends, normally somebody will be puzzled, or even many of the audience may be puzzled as to why such an unusual subject has been taken. Is it I go ahead with a belief that lawyers really do not understand how to read the statutory law. But I shall share with you that in the system of legal education, the teachers, the community of teachers, take it for granted that like reading any other text, you would read the law, you would read the codified law, and you are likely to understand it. No harm in having this understanding. However, for any process of learning, certain basic things have to be shared by somebody at some time in the life before it becomes too late. Because if some ideas about some basic thoughts and taught or told to the lawyers late in the life, it becomes too late. So better start it at earliest possible age in the life. That is the motto behind this. Let me make some initial introductory remarks as to the basics of reading and understanding the law. How I coined it, termed it, I'll repeat it. Basics of reading and understanding the law. See what happens. Being a lawyer in the modern time and being a scholar of language in old days was more or less synonymous. They stood on par with one another. Why? Comes to precision in the matter of communication, when it comes to precision in the matter of writing down the terms of an agreement, any document, any pleading or a judgment, what becomes imperative is absolute mastery on language. What is a language? Is there anything called legal language? People feel that there is something like a legal language. In fact, law operates in the common man's life, and the life is never full of law. Life is intermingled. Do something reading the book of law, but laws are born after the human being's life prospered. Therefore, primary requirement of understanding the law is understanding the life, understanding the facets of life, and understanding the mode and device of understanding the life. How is it understood? You understand the language, as I commonly communicate, that you start learning the language through your ears. The mother starts talking to the child in her own language which child doesn't know. Child starts receiving the phonetical or vocal communication aided with expression, and in the course of development of the brain of the child, his memory about the voice and expression and feeling also gets cultivated. More you learn in the life, you grow, you come across numerous things, and each thing or article around you is identified by some phonetic identification. There is a voice communicated to that. Each voice, the meaning of such voice is depicted in your brain, in your mind. And thereafter, a dictionary has been built into the mind of the child, into the brain of the child. After some voice, some meaning has been attributed. The mother takes the child for taking it to bed, she has some other way of communicating. The child is taken for playing, there is some other way of communicating. The child is taken for the food, there is some other way of communicating. Every time there is a different voice for different meaning. This is how the mind and now when you come to a further level where different words have to be understood, you learn them through your teacher or all those around you, be it a mother tongue or any other tongue, any other dialect or language. You learn the words through ear. When you come to the law, what difference you ought to make is understand every word from the history of that word, which is close in every, but exact meanings have been narrated into the dictionary. I'll give one small example of a word as we have understood in Indian Contract Act, not in the act but in the discussion relating to Contract Act. You may recollect that your teachers pronounced the word quasi-contract. Do you recollect? I believe most of you. But see, the interesting part of it, the word quasi is not used in the text of the Contract Act. The text used in the Contract Act is certain relations enforceable as contract, though not a contract. When you go to the dictionary and find out, because I did it when I was a law student, the term quasi described in a particular manner in Chambers Dictionary, while it was described in a slightly different manner in Oxford Dictionary. Using multiple dictionaries and using thesaurus helps you to understand exact meaning of the term that you are going to use, that you are going to understand. While coming to the, have to bear in mind that you have to be extremely specific about understanding each and every word used or employed in the process of drafting. Without this, your understanding of statutory law is not complete. I often describe Ratan Lal and Dheeraj Lal's Indian Penal Code, Commentary on Indian Penal Code, as a school. I do not regard it as a book. Ratan Lal's book on India, another book authored by him, operates like a school. He takes you to the body of section. He tells you to understand each and every word contained in it, makes a comment on that, and thereby Ratan Lal and Dheeraj Lal make you to understand the law. This is what is the basic about statutory law I wanted to share with you. Now I will tell you how to begin reading of a statutory law. I have been insisting on reading of any book, of course, including a book of statutory law, with a certain basic norm. What is that basic norm? The basic norm is, I'll illustrate with you. Come to, you have to begin reading from the very first word to the bottom of word at the cover page. Now I had shown you the Code of Civil Procedure Code. Now you have already passed LLB, LLM or something more. Did you ever go to dictionary to find out the word code? Can anybody tell me, give me your feedback, have you ever seen the word of in the dictionary? I have seen people confusing the word of to thee to a and what not. Therefore, you need to look at every word. And friends, keep it in mind that a question will arise before you as to how long you should spend time in reading one enactment. If you follow my advice, you have to go to dictionary, consult the dictionary for each and every word in one enactment. You may feel that the estimate of time will go that for reading one enactment you will need months. It doesn't matter because this is the basic work to be done. Have you ever seen any wrestler entering into the field without any preparation? The day he court of fighting, never. He has to do a lot of tremendous bodybuilding, tremendous exercise. Going to dictionary and reading each and every word in the dictionary is an imperative thing which you have to do only once in the life. Because once you compile your dictionary in your brain, understand each and every word, arrange them in sequence, these words are going to recur while you read the law and will help you like a searchlight all time standing in your book of law that you are going. You have it falling on your book, elucidating a delighting meaning of every word. Anything new comes, by frequent use of dictionary, you become so extremely friendly with the dictionary. It will look funny, but I'll tell you the picture as if it is portrayed in front of you. You touch the dictionary and you want to start with the word S. Where you touch your finger, you shall find S. And you shall quickly surf the pages and go to that word. Nowadays, you don't go to dictionary. I know you have dictionary.com and many softwares. You just click on the word and you get the meaning of it. Very nice. But parallelly, you will have to cultivate the habit of immediately going to the thesaurus, comparing what are the analogous meanings. What is the difference between analogous and similar, similar and like and resembling? Unless you get each and every word from a word which is of the same character near to that, meaning nearby that, you cannot remember that word. I recollect one of my schoolmates asked me when I joined law and gone to my village that, Bal, please tell me, how do you remember the sections? How do you have them by heart? इतकं सगळं पाठ करता का असं त्यांनी मला विचारलं. Definitely not. You are not expected to mug up the sections by heart. Nevertheless, you do not afford to place everybody. I often offer a challenge to many of my friends who are critics of the codified law because it is a common fashion. हे इंग्रजांच्या काळातलं टाकून द्या. Throw away these Anglo-Saxon laws. That is a very common proverb. But have you ever discovered, have you tried to exert whether these laws are bad because they are made by British Englishmen? How many of the codified provisions resemble with concepts basically groomed in India? I always quote Evidence Act, where it is provided that oral evidence is excluded by documentary evidence. This rule is adopted in Manusmriti. How can it be bad because it is written by British people? It refers to the human tendency, human mind, rules of economic behavior of human being, limitations of human memory. Try to understand the law from this point of view, that a common proverb which I put in my dialogue, that cultivate the habit of quarreling and fighting with the law becomes possible only if you have mastered on the language. Marathi or Hindi translation of this term is very fine. Bhasha Prabhu. You have to have absolute mastery on the language, and then reading and understanding of the law becomes very easy. Now, with this elementary background, I will take you to the process of reading, and I'll tell a motto and a lesson behind it. What is the importance of reading? How does it matter? If you read it like a reads, child would try to read through each and every letter and would be unbothered about the word. He is reading a sentence, for example, I'll read, put it in a common fashion and then show a distorted version also. The river Ganges flows with extreme flow. Now a child who has not learned reading the words, how did the river Ganges flows with, does it convey any meaning? But if it is read by understanding each and every word, saying that the river Ganges flows with profuse flow of water. Therefore, giving due emphasis to the appropriate accent or pronunciation of the word helps conveying the meaning. Proper pronunciation of a word helps you recapitulate the word learned by you. And when not learned by you, it takes you to the dictionary, learned by you, and formulate a concept underlying the philosophy referred into that section. This is what I am telling you about the reading. But I must take pause and come back because I have taken you directly to the reading of the definition or sections. I had to do something before that. That I shall tell you now. Come to the, I have told you to come to the cover page. Okay, you have read the cover page. Then you come to the internal page. What is written? Code of Civil Procedure Code as amended by so and so. All details are given. So this tells you that this act has undergone so many amendments. So you have to keep it in mind that the law that you are going to read is updated to a particular year. This is peripheral and but general information. Then you see the name of the publisher also. Then a sort of a disclaimer clause. Nobody shall. This is very important. If you read this, you understand what is the law of contract, what is copyright. Any part of this book shall not be without permission of the author, reproduced, etc., etc. Read everything. Nothing is unimportant. Everything is important. Have a diary. For few months, I don't say for lifelong, you should have a diary and remember every word. If somebody asks me, I'll answer how to remember the words also. I'll not tell it voluntarily. Then you come to the arrangement of sections. I'll take you to the arrangement of sections. In the book, you have arrangement of sections. In my humble view, knowing the anatomy of the statute is very important. Which word I have used? I have used the word knowing the anatomy. What is anatomy? Anatomy is the body structure. It is the description of the structure of a statute. Read every heading of every chapter. I have been recommending that one who wants to understand any enactment, cultivate the habit of having a poster of one chapter. Put it on your wall in the morning, have another chapter in the evening, watch it till next day's breakfast, have another poster for next day. It will contain list of chapters, list of sections. Why you need? It helps you to understand perpetually. What word I am using? It helps you to understand perpetually the scheme of the statute. I shall share with you interesting experience why I am emphasizing on this. Friends, I had fortune of somebody telling me that read the Code of Civil Procedure, not the bare text, but the practitioner's edition at my LLB level. Pardon me, but had occasion to read for examination of 50 marks for Civil Procedure Code, practitioner's edition, which ran into not less than 2200 pages. and the arrangement of those sections, arrangement of commentary, that I was able to analyze and put into my brain, came to my help. In what fashion? If you have visited a garage of a mechanic, he just picks up a hand and a small boy brings a spanner of a required description. Provisions of law must come to your help. There is a Sanskrit proverb. I will share it right now. Sa vidya ya vimuktaya. That knowledge which comes to your help when you need it, that is real knowledge. So when you remember whole anatomy, whole scheme of sections, of sections, each provision comes to your help when you are standing before the court and a question is put appear before you. All of the sudden, and your juniors start asking you, because by that time you are pretty senior. Your friends and juniors ask you, how did you recollect this particular section? That recollection is possible with the device of meditation and exercise that you have done. So first, in order to understand the anatomy, understand the scheme of sections. What are the scheme of sections? Correlate it with the contents. The first chapter is preliminary. Read every heading of the section. You are not going to section right now. You are only reading the heading of the section. If upon reading of the sections, a curiosity arises, crops up, well, you may go to the section also. Try to understand. Not in the deeper sense, but at least some basics of it, as to know what the scheme is, what the section is, why it has been so put into this chapter. After you understand the chapterization, go up to the end. And now you understand a very interesting thing. Anatomy of all statutes is basically analogous, more or less similar. For example, if you are asked to paint a human being, you are bound to show head, ears, eyes, lips, shoulders, then the trunk of the body, hands, and then the foot, right? So every statute has got a fixed type of anatomy. What is that? It will have a title, it will have its date of enactment, it will have its scope of enactment, it extends to territory of India. It used to be earlier except Jammu and Kashmir or something like that. So extend, if it is a state law, it shall extend to State of Maharashtra or something like that. It extend. Then comes date of enforcement, from which date it shall come into operation. Then comes the definition clause or interpretation clause. Then comes the scheme of the particular enactment, divided into chapter. After it is complete, then you come to the last chapter. What it contains normally, repeal and savings. The standard anatomy. Once you fully understand the scheme, anatomy of enactment generally, it becomes very easy and comfortable for you to study any other law. So what is primarily important is understanding certain enactments, few enactments as basic study. Once you do it, it becomes a road paved by your own brain. Pick up any law and you get into a particular section. You have never read that law. It comes to your provision. This becomes possible only after you have fully acquainted with the scheme of the anatomy of statute. Now I'll go one step ahead. You have understood the chapterization, you have followed the anatomy, general arrangement of sections. Now you should go to the statement of object and reasons. Why this enactment was made? This gives you a viewing window. You have at the door a peeping hole through which you see what is outside, right? Here, statement of object and reasons give you a periscope through which you see what is going to come in the inside, what is going to be inside the statute. This enactment was made for regulating and laying down the procedure to be followed by the courts and by litigants for effective adjudication of disputes arising before the court. What is the aim and object? An act to lay down the provisions governing the relations of parties and certain rights and for defining the effects of breach of contract and whatnot. So this gives you a view of what is going to be contained in the statute. So reading statement of object and reasons, and again going back, repeating the same record that I am going to chant number of occasions today, that even while reading the statement of object and reasons, you must harp upon, you must bank upon every word that appears in the statement of object and reason. Now coming to the definition, and now coming to actual reading of the enactment. I would like participants to come and start reading some definitions. Let us start with Indian Contract Act, and let somebody read definition of proposal.
Yes, sir.
Yes, please do it. Yes, unmute yourself and do it.
Yes, sir.
As ma'am, are you reading or should I read the definition of proposal?
You read definition of proposal, Mr. Joshi.
Ritvik, shall I read it?
Okay, I'll read it. When one person signifies to another willingness to do or to abstain from doing anything with a view to obtaining the assent of that other to such act or abstinence, he is said to make a proposal.
Okay, now how I would read this definition, I'll tell you, so that its meaning must get communicated. Okay, see, when I'll have a pause, when, what does it suggest? It suggests a point of time on when an action is to be taken. What is that action? When one person, what does he do? Signifies his willingness or abstain from doing something with an object of seeking assent of the other. You read it again with this possession, with pauses of this type.
I think we've lost connectivity with him.
Okay, you can read it.
Sir, I'll read it.
Yes.
When one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other to such act or abstinence, he is said to make a proposal.
Now I'll tell you. Since it has been a common criticism that these are Anglo-Saxon laws and must be amended or must be scrapped, now let anybody come ahead and tell me what change is possible. Come on, substitute any word contained in this definition. Can you change the word one? Can you change the word person? Can you change the word signifies his willingness? What is signifying? How many of the people in attendance of this lecture have ever seen in the dictionary the word signify? No, I am more than sure, because this is not a part of our training. And if you really want to understand, read and understand the law in a correct manner, you must cultivate the habit of going to the dictionary there and then. The concept of signifying is so interesting. It may be done in oral fashion. It may be done in an a different way of communication. There could be a signboard. There could be an email. Things are put up for sale in the shop. Prices are put and available for sale is a board put. Could it be a significance of signifying the willingness? It should. But I remember one question which had appeared in the ICWA examination on this definition. It's very interesting. I'll repeat that question. A man sits down with a set of parrots kept up for sale, displayed for sale. And whenever a buyer comes and stands up, or anybody comes up and stands up, the parrot announces that my price is rupees 10. My price is, third one says my price is rupees 20. The question was whether offer is complete. Is there an offer at all? Is it made by a person? Has he signified his willingness to do or abstain from doing? None of the things. So who shall signify? One person. The person has to be physical entity, existing human being, or a legal entity. This is how you go to the definition and expand of the that you are going to portray on it. So read the definition once again, and you will follow what emphasis is required for the word person. Read it again.
Yes, sir. Yes, sir. When one person signifies to another.
No. You have to pause. There is a pause. Even while reading for your own purpose, without loud voice, you are reading it for yourself. Even then, you should take a pause. When one person.
Yes. So shall I continue?
Yes, yes.
Yes. When one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other to such act or abstinence, he is said to make a proposal.
Good. See what happens once you have done. You have thereby isolated each act to be done by somebody or a thing contemplated by the statute. Thereby, the meaning of whatever you wish to say stands communicated. This would become possible only when you cultivate the habit of reading the sections in a rhythmic manner. Rhythm is not sheer joy, as is the communication of music and singing also. Here is a case where you need to have a pause. I have introduced in the beginning itself why a pause is required. This helps your mind to fill in the gap or convey the meaning to be communicated by that word. So therefore, once again, when you continue. When
one person signifies
have a
to
pause.
another. One person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other to such act or abstinence, he is said to make a proposal.
Make a proposal. Now, while reading a new section or anything that you want to do, cultivate the habit of having a small pencil and make a faint mark. You can rub it later on. Don't have a B6 pencil. Have a B type of pencil, nor have HB hard pencil. Mark or underline different clauses or words which constitute a clause. Here, when is one clause? Because it indicates the process of somebody doing it. One person is another clause. See, here person or person will include more persons also. If there are joint owners of a property and they are making an offer, so person will include persons also. When one person signifies his willingness is another clause to another. Now, why this another is required here? If somebody is standing on a mountain and lonely shouting that I want to sell my property for 1,000 rupees, is there a communication? Is there an offer? Therefore, two persons in the process of proposal are imperative. So this another person is offer. Yes, once again, read it once again.
Yes,
When?
sir.
Yes, please read it.
When one person signifies to another his willingness to do or to
Right.
abstain from doing anything with a view to obtaining the assent of that other to such act or abstinence, he is said to make a proposal.
Now you have, I believe, with this reading, you have understood the definition of proposal. Another interesting definition you must read is of communication. Yes, somebody should read it.
Yes, sir.
Yes. Yes, you can read.
Yes, sir. Yes, sir. I'm just opening it, sir. I'm so sorry. The section 3, communication, acceptance and revocation of proposals. The communication of proposals, the acceptance of proposals, and the revocation of proposals and acceptances, respectively, are deemed to be made by any act or omission of the party proposing, accepting, or revoking, by which he intends to communicate such proposal, acceptance, or revocation, or which he has the effect of communicating it.
Now there is when communication complete. Next is.
Yes, sir. The communication of a proposal is complete when it comes to the knowledge of a person to whom it is made. Further, the communication of an acceptance is complete as against the proposer when it is put in a course of transmission to him so as to be out of the power of the acceptor, as against the acceptor when it comes to the knowledge of the proposer. The communication of a revocation is complete as against the person who makes it when it is put into a course of transmission to the person to whom it is made so as to be out of the power of the person who makes it, as against the person to whom it is made when it comes to his knowledge.
Okay, I'll make a small comment and then go to the reading of this section. See what happens in the process of skill of communication in the life. What I'm saying, communication skill in the life for lawyer, for teacher, for anybody. The definition, section 3 relating to Contract Act could be Bible of skills of communication. If you understand it, it is a lifetime guide. I think I have very firmly told what I want to say. Does it require repetition? I may do it if required, because n number of repetitions will not matter. The concept of communication as defined in the Indian Contract Act is like Bhagavad Gita or Bible in the field of process of communication in the life. Be a lawyer, teacher, a common man, anybody. See to this definition from this angle. That is the important. Now, while reading the first part of communication, communication of offer, communication of acceptance, communication of revocation or acceptance of revocation. This is a class of transactions contemplated. So while reading this definition, you may read only one. So we'll presume that rest are there and try to read the first part again.
Yes, sir.
Please do it.
Communication when complete.
No,
The,
earlier.
the earlier part. Okay, sir.
Yes.
The communication of proposals, the acceptance of proposals, and the
Now skip
revocation.
that. The remaining 3 parts you may skip for convenience of reading, because now they are a class.
Okay. Are deemed to be made by an act or omission of the party proposing, accepting, or revoking, by which he intends to communicate such proposal or which has the effect of communicating it.
Now, as I mentioned to you, what is an act? Whether omission is an act. If omission, all these questions get answered only when you go to dictionary. I know somebody will feel that I am repeating the same thing like chanting the same name of God or something like that. Yes, for me it is God. No excuse. It has to be imbibed in your mind in such fashion which is describable as indelible. It would never be wiped out from your mind. That it has to be done in this fashion only. And once you understand the isolated specific meaning of each of these words, there is no possibility that you are likely to forget, likely to have it. So according to me, this possession at the time of reading helps you to have the meaning of the particular section imbibed in your mind. I think as far as the process of reading and understanding the law is concerned, my primary discourse on this aspect is complete. And I would now be open for discussion, because it is already 45 minutes are over, and there are some questions. I would definitely make an effort to answer those.
Thank you so much, sir. We are expecting few questions. So meantime, question comes from the viewer. I would like to ask you that when, as a lawyer, we argue in front of the court, I have always observed while appearing before you that you are very careful. That you are very careful that whether if someone becomes loud while arguing in court. So can you just tell us that how one should conduct, how the person should conduct while arguing before the court, especially about voice modulation?
Yes, see, loudness is a very relative term. I'll describe in this fashion. I regard one of my friends that he is a non-irritating loud. His voice is non-irritating loud. What is now non-irritating loud? A cracking sound. You understand what is cracking sound? If somebody is loud and is having a cracking sound, it results into the mind and brain of the why judge? Anybody in front of you, he gets irritated just by listening the sound. You know, some birds, why you like quail? The voice is loud. Have you ever been angry with the sparrow? But do you like the voice of a crow? You like the voice of a peacock? But would you like the voice of the bird? They call it bird fever. पावसा म्हणतो आपण त्याला. Brain fever. The bird is called brain fever voice. So it depends on the irritating character of the voice. And I believe you people are smart enough to know that there are people in the field who work on voice modulation and voice culture. A man with a cracking voice or torturous type of voice, his voice can be modulated. So voice modulation is very important. Your proper humble facial expression. Loud voice by itself would never matter for the judge, but the tone behind it matters. Because I have come across many lawyers who are loud. but that loudness accompanied by a sort of irritating temperament creates a complication. Therefore, that loudness can be modified, must be modulated. Ultimately, what is important? Your faith that you are likely to communicate. You have got a sincere case, whatever you have to argue, you are going to do it. Communicate in a proper manner. See and look at the judge. Lawyers following the practice I fortunately used to do. I would never open the mouth unless the judge is attending to my expression. I would wait till there is a meeting of the eyes with the judge. There is a judge who doesn't look at me. His eyes are on the downside. He says, "Come on, you argue. I am lending my ear to you." Very nice. Then I would go narrating the facts, find out whether those are being received, and would not utter next sentence unless my earlier sentence has been received and responded to by the judge. Very sad, unfortunately, particularly at Mumbai, lawyers are not bothered as to whether judge is listening. And of course, there are few lawyers who are very serious about their words being received by the judge. No sentence would come out unless judge is responding to that. You are not addressing to the wall. I have used this phrase in the court. Are you addressing to the wall? You are addressing to the judge. Look at his expression, whether he is receiving, whether he is understanding, whether he is taking down the notes. Sometimes the issue is very complicated and the judge is keen on taking down the notes. Would you not stop till the judge takes down the notes? Here, taxation, you are arguing a taxation matter. Will you not allow the judge to swallow your? Therefore, in the process of communication, causation, as I am telling you, while reading for yourself is important, voice modulation is important for you, it is equally important for the judge. And since you are still waiting for a question, I'll just mention one interesting process of reading and interpretation. Are there some questions?
So there is one
I'll just complete what I was.
Yes, sir. For the complete, then I'll share the question.
Just take out Rain Martin's grammar and focus on the chapter of clause analysis. This will help you making the clauses of sections when you read them. Not exactly or not concurrently with what has been told in the Rain Martin, but reading the section with the help of the process of clause analysis as prescribed in the Rain Martin's book. It would help you in understanding the law. It is one of my personal experiences that I am sharing with you. Please go ahead.
Question is by Advocate Chandrakant.
Yes, sir, there is a question that I am seeing. If you are going to put that, how to remember the words?
How to remember the words?
Yes, good. I have told it, but at the cost of repetition, I would do it. See, I have in the beginning itself gave illustration of some word. I'll give another illustration now. You know the word color, you know the word paint, you know the word shade, you know the word tent, right? These are the words of the same category or same character. The very nice idea or simplest idea of remembering is understand each word from the dictionary and comparing it for yourself. And once you understand the different shades of the meaning of the same, different words of the same category, you would remember it. You would never forget it. This is one thing. Secondly, with rising age, the method of remembering changes. Be it that you have a student in front of you who is up to 6th, 7th or 8th standard. I don't mean to undermine them. Now they are very smart. They're very smart. So they would, in my childhood, the exercise was to write down the word and its meaning for 5 times, 10 times. When I went ahead in my life, the practice was to focus and ponder on the word and its meaning, either formally by shutting down the eyes or dimmingly shutting down the eyes and remembering the spelling and meaning. Have it by heart 5 times, 10 times. If you could cultivate memory, like inscription on silicon that is done in data in computer. Write a word and it is never forgotten. Have the quality of concentration of such nature that you would never forget the word. To start with, mug it up in your mind, close the eyes for a second or two, remember it twice, thrice, and you would never forget it. Another exercise which teachers in Sanskrit used to get done, that use all forms of the word. Your best, bad, worse, worse, walk, 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 kill, 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 killed, killed. If you use all forms of words, all its derivatives, arrange them in sequence, you would never forget the words. And remembering the word is important, remembering the section is not important. Once you isolate the meaning of the word and remember it, take it that the section you have by heart. Yes, next question.
So the next question is by Advocate Sri Krishna Ganbawle. He is asking, sir, can you please tell us the importance of
Yes,
diction while addressing the court?
yes, I'll tell you. Yes, I'll give an illustration, and I think that illustration is a reply. Friends, as we see at Mumbai or at some places where people have learned formal English in English schools, English medium schools, and those who are fond of modern accent, they use that language. And I, for myself, speak medium school, learned English from Maharashtrian teachers, and my accent is accordingly modified. At times, I remember that some of my accent is criticized, some of the words get. But now, I have the funniest part I am telling you. Go to Supreme Court, sit down for a few days at own cost or at the cost of your client, doesn't matter. Sit near as you can, near the dais, and listen to numerous lawyers coming. And a lawyer from Bihar comes and he pronounces the word lawyer. Okay, how does he pronounce it? My lord, the lawyer did not remain present. After he uttered the word for 7 times, I understood that whom he is referring is a lawyer. Then an Asabi comes and puts an accent in his face. Fortunately, the honorable judges of Supreme Court know that they are going to have such plurality of diction and variety, and therefore they have toned themselves to listen to it and understand it. But for a lawyer, it is ideal. It looks funny, but it's ideal to have the accent the Tamilis do. I remember one teacher dictating the notes to the student without being required to tell a single spelling. How would he say? And the Shakespeare in his drama on Othello has portrayed each of the characters in such a fashion. Now I love it, but my emphasis is on the very definition of communication. If you pronounce a word and it doesn't reach the judge, what happens? Your very effective argument in a very beautiful language having American accent has not reached the judge. Therefore, appropriate grammar, appropriate pronunciation, commonly understood in Indian territory is most welcome. This is the way the diction before the court should be there. I would go even to this extent that those who have formally learned in English schools and have learned some sort of a fashionable accent and diction must come down to the Indian accent. Because I remember I told some of my friends to see the movie Invictus, where I very distinctly remember Nelson Mandela's diction. I recommend that you must do it. Watch the 1965 movie My Fair Lady. What happens? Your knowledge and accent does not go together. You speak very fashionable language, but you do not know the culture in which you are groomed. This is likely to create numerous complications. Therefore, having learned very fine English also, you have to see to it that it doesn't become an impediment in your communication. Rather, your communication should be accelerated accent. I think I have tried to answer nearby.
Yes, sir. Thank you so much. The next question is by Advocate Vivek Bivalkar. He is asking.
I read the question. I read the question.
Yes.
I would not name the honorable judge. He was sometime Chief Justice also retired in the Supreme Court. I am telling about only one word, and I'll tell you what that word is. I had used the words villages and hamlets in my pleadings. What was the response of the judge? That Mr. Joshi, we are born in India in small places and taught in small places. Try to be simple. Simplicity is the beauty. Using hefty Latin maxims is welcome, but without knowing them, what happens? I'll tell you one very humorous situation occurred. I will name it because there is no defamation of any lawyer. One good lawyer of earlier generation than mine, at Aurangabad, he appeared in the court of Justice Mohta. Coincidentally, Justice Mohta's President or Justice Mohta's father, AP Mohta's father. And he stood up. Justice Mohta used to expect lawyers to argue even the first appeals. No harm. I used to hear the appeals for final disposal at admission stage. So no harm in hearing the appeal at admission stage. But he wanted the lawyer to argue the matter for admission hearing. The learned senior, a man of very good standing, he has already crossed 65. He said, my lords, I expect my lords to expect from me that I will proceed to argue the stay application instead of arguing on first appeal and waste my lord's time. The court said, all right, let us respect the man of standing. He would not argue a useless case. And all right, you go ahead. And he argued in one sentence. What was that? My lords, I know I have a debt to pay and a decree. I have no money and my friend is not a Shylock. Learned adversary touched my ears and asked me, what is he saying? Good enough, that judge was learned and he was not required to be told what Shylock means. But if the adversary and those sitting in the court do not understand your hefty language, is it welcome? Gandhiji and Nehru are known for simplicity of their language, not for difficultness. Be as simple as you can. Simpleness is richness. Being gaudy, there is a possibility of your being showy. Simplicity is like a beauty which does not require decoration. There is a proverb in Marathi, you people must have remember it. काही ती थोडी फेमिनाईन आहे, महिलांच्या बद्दल आहे. काही दागिन्यांची शोभा त्यांनी घातल्यामुळे वाढते, त्यांची शोभा दागिन्यामुळे वाढत नाही. त्यामुळे दागिन्यांची शोभा वाढवणारं सौंदर्य पाहिजे. The content and the language should have a beauty that it does not need external decoration. मला आठवतंय मी एका जजमेंट मध्ये एक फ्रेज लिहिली आणि मला नंतर वाटलं की मी एवढं अवघड लिहायला नको होतं. फार अवघड नव्हतं ते. एका चोराच्या मुलाने चोरी केली होती आणि तो अँग्री झाला आणि त्याने आपल्या मुलाला मारलं. इट रिझल्टेड इन हिज डेथ. मी असं लिहिलं की द फादर हू हिमसेल्फ बिलॉंग टू द ट्राइब ऑफ मून्स did not want his child to join the tribe of moonsmen. इंग्लिश लिटरेचर मध्ये मून्समेन हा शब्द चोरांसाठी वापरलेला आहे. आता मला गरज नव्हती हा शब्द वापरायची, but it just happened that in the flair of writing I am criticizing myself. I should have simply said the father himself, who was a thief, did not want his son to be a thief. Good enough. Simplicity is more important, which helps you being communicative. Now I remember one of the words which was coined. There is a book, I would like you people to buy it. The book is titled as Law Talk. It is a compilation of various phrases which have cropped up, which have emerged and have got settled in the field of law. But those who, I remember a phrase, the lawyer arguing that phrase, that my lord, let it not be hang for the lamb. Now, what is this hang for the lamb? This phrase has what a history. In England in the old days, before 100 years, any minor theft was provided for punishment of capital punishment, sentence to death. So in one case, a lamb was stolen and a complaint was filed that he has stolen my sheep. And the jury was bent upon giving capital punishment. The lawyer argued that, my lord, it is a lamb, not a sheep. And the judges held that the lamb is a sheep, and he was hanged. So a phrase cropped up, hang for the lamb. There is another such phrase, that a minor girl was subjected to sexual abuse. And he said, I didn't know that she is a minor. This concept is, you provided a phrase that she was welcome, no issue. Lawyer should enhance his vocabulary, his learning, his depth of knowledge, his depth of history, but it should not be a burden. What is, according to me, more important is being simple. Be as simple as you can. History can be told in simple manner, simple language, simple words. Our length of judgment is increasing because of this glorious language. My insistence, my recommendation is prevent yourself from falling into the habit of being difficult. Yes, we can go for next question.
Yes, sir. Thank you so much. I believe there are no more questions. The only request by Advocate Kishore Jagdade, practicing in Maharashtra Administrative Tribunal, that sir, please, that he would like to hear you on drafting skills and also on service law and principles of natural justice. Thank you so much, sir. I'll just sum up.
Going to the seminar at Sangli Bar. Sangli Bar Association. Yes, I understand. Sangli Bar Association is going to have a webinar, mostly on 2nd or 3rd. So I'll post its link to you and you can circulate it.
Definitely,
that is going to be on the plaint and written statement, and temporary injunction application. It will cover some many facets of drafting.
Definitely.
That will be mostly on 2nd or 3rd of June.
Yes, sir. Thank you so much, sir. I believe the key to understand any statutory provision starts from dictionary. So first, all of us need to understand the meaning of each and every single word. And then then we have to read it very slowly, carefully, by understanding each and every single word. Then the key to successful in our practice for the best drafting is, the key is simplicity. I believe that, and I'm sure that everyone will follow these words of wisdoms. Now I call upon Advocate Adhivakta Joshi for word of thanks.
I, on behalf of Adhivakta Parishad Mumbai Unit, sincerely thank you. We express our gratitude for sharing your knowledge, wisdom, and experience on our platform. The whole of your speech was the importance of communication and mastering our language, not only in advocacy but also in everyone's lives. So once again, as I mentioned earlier, how to read laws, how to communicate effectively are not only essential for lawyers and advocates, but everyone who relies upon communication in their day-to-day life. I once again thank you for sharing your insights and wisdom and knowledge to our platform. I also thank everyone who has joined us via Facebook and YouTube. Thank you very much, sir, once again for coming on our platform.
Namaskar. Thank you, everybody. Thank you.
Thank you so much. Our the next and the last concluding lecture is scheduled on Saturday in morning. The details of the last lecture will be shared on our Facebook page very soon. Kindly follow our Facebook page, like it, subscribe our YouTube channel. Thank you so much.